Speaker. Today we have the Colorado Oil and Gas Association's attorney, Mark Matthews. He's a shareholder with Brownstein, Hyatt, Farber, and Schreck. His practice concentrates on environmental and energy law as well as complex litigation. He has a lot of notable experience on environmental litigation issues in the mining, water, and oil and gas industries. We have his bio in the book along with everybody else's. And so with that, please give a warm welcome to Mark Matthews to discuss the fracking battle in Colorado.
Good afternoon. Can everybody hear me okay? No? Hey, Brian. I think we need to ratchet this up. Usually I'm not told to speak more loudly. How's this, better? How's this? Okay, I'll try and speak up too. And this is working as well. Well, first of all, my name is Mark Matthews, as Brian said. I'm a partner of Brownstein, Hyatt, Farber, and Schreck. We have an hour to go here in this presentation, and I have kept my presentation relatively short because when I go to events like this, I always think the Q&A is a lot more interesting. Believe me, you don't want any lawyer to go on for too long. It's not good for anybody. And as you'll see in some of the decisions we're going to talk about, that goes for judges too. So save me for myself. Think of questions during the presentation, and please don't be shy about asking them. As you see, this is a very quickly evolving area. It's an area of law that is changing every month, it seems, and so there really are no dumb questions. As Brian said, I am COGA's outside litigation and regulatory counsel, and in that role, I have kind of a bird's eye view of what I have called the fracking battle in Colorado. Now, it's a very provocative name, and as those of you who work in local government and those of you who are operators know, the norm is certainly not contentiousness and battle. Most operators drill successfully in Colorado. Most local governments regulate oil and gas development relatively peaceably. I think we all agree that that is the norm. But I am talking in this presentation about the outliers, the events that grab headlines, because those are the events that make the law that then govern this relationship between local governments and oil and gas operators for the next 5 years. So what we're going to talk about here is circumstances where a local government may not want oil and gas development, or projects that are very controversial, that are perhaps near residential areas, or near schools, or near the north side of Denver, where practically every operation seems to be controversial these days. That's what we're going to be talking about here today. Now, as I mentioned, fracking battle in Colorado is occurring in a lot of different venues. It's occurring in the Capitol. It's occurring certainly in courtrooms, which we'll talk about. It's occurring at the COGCC. It's occurring in boardrooms in counties and in city councils throughout Colorado. So choosing subjects for this presentation is somewhat challenging. But here are 3 things we're going to be looking at. First is the law of operational preemption. That's the heart, the legal doctrine that is the heart of what local governments can regulate and what states can regulate. And that's going to take most of our time today. But we need to talk about potential legislation. Because as you'll see, operational preemption is a creature of state law. It functions based upon what the state constitution says and what state statutes say. That's why New York famously has banned hydraulic fracturing. The Colorado Supreme Court, as we'll see last year, said local governments in Colorado can't ban hydraulic fracturing. Diametrically opposed decisions, but they're both correct because the state constitution and the state statutes in New York and Colorado are different. So we need to talk about potential legislation. Finally, I've thrown in the Martinez decision. Now, that's a Court of Appeals case that came down last month. I suspect many of you have heard of it. There's been a lot of press about it, despite the fact that it's only a Court of Appeals case and not a Supreme Court case. We need to talk about that case, because if it is not overturned, it has tremendous impact. I would go so far as to say that it may hold the COGCC under siege, because it questions the way the COGCC has done rulemakings and issued permits over the last decade. and it questions what moving forward it means to get a permit or a rulemaking in front of the COGCC, and it perhaps even calls into question already existing permits. That's part of the reason I want to talk about Martinez. It's also part of a growing trend where courts are second-guessing agencies, and you see that in Colorado, and you see it nationally. Traditionally, courts have deferred to agencies' interpretations. They say, you, the agency, you, the COGCC, have expertise in this area. We're just judges. Unless you really blow it, we're not going to overturn your decision. The Martinez case is part of a growing trend where when there are environmental impacts that issue based on an agency rulemaking, courts are getting much more aggressive in how they interpret an agency action. So I want to talk about Martinez to finish. What is operational preemption? It is really an issue of who decides. Now let's be clear. Local governments have a role in oil and gas permitting. The Supreme Court said last year in Longmont that oil and gas, the regulation of oil and gas, is a mixed matter of local and state interest. The COGCC gets to rule, and local governments, with regard to land use, get to regulate. Operational preemption tries to draw the boundary to say how far can local government's land use authority go in regulating technical aspects of oil and gas. The state regulates oil and gas through the Oil and Gas Conservation Act, and it gives the COGCC very broad authority to regulate every aspect of hydraulic fracturing. And with that authority, for those of you who have tried to wade through COGCC regulations, it's a great exercise if you want to fall asleep. There are hundreds of pages of regulations that regulate virtually every aspect of hydraulic fracturing, from before the proposal is even made to notice requirements, to after the production ceases, through reclamation. It's a true cradle-to-grave regulatory regime. What's really fascinating now is in the last 3 or 4 years, we are seeing local governments replicating those kinds of thorough regulations. So we'll be talking about Boulder, we'll be talking about Adams, we'll be throwing in Broomfield. Most of those jurisdictions, or I would go so far as to say all of them, have very extensive oil and gas regulations that regulate, like the COGCC, every aspect of hydraulic fracturing, including very technical areas like air and water mitigation. The potential for a clash is obvious, isn't it? What happens if the COGCC permits a well and a local government says, no, you can't drill that well? What happens if the COGCC permits a well with certain air and mitigation requirements, and a local government comes in and says, those mitigation requirements aren't strict enough? The idea of a conflict is apparent to all of you, I hope. So who decides? The Colorado Supreme Court last year took a step but only a step, big step, in resolving this issue. Longmont banned hydraulic fracturing in 2013. Fort Collins imposed a 5-year moratorium on oil and gas and hydraulic fracturing in 2014. The COGCC sued Longmont. COGA intervened. COGA sued Fort Collins. The COGCC was not in that case. In both cases, the district court said that the ban and the 5-year moratorium were illegal because they nullified the COGCC's interest in regulating oil and gas. That's the word the court used, nullified. And because it rendered superfluous, another word the court used, hundreds of pages of COGCC regulations. If the COGCC has hundreds of pages of regulations governing hydraulic fracturing, obviously it permits it. You couldn't drill until last year in Longmont or Fort Collins. There was an obvious conflict, and that's how the Supreme Court decided that issue. Now, many people in the environmental community, and to some extent local governments, have said these are narrow decisions. All the Longmont court said is you can't ban hydraulic fracturing if you're a local government. And all Fort Collins said is you can't have a moratorium of more than 5 years. But I think that is an incorrect reading of the cases, and I think most reasonable commentators agree with me. Because in fact, those two cases establish the groundwork for the next decade of how far local governments can go. Those cases did two things. First, for the first time in 40 years, we have a clear definition of what operational conflict is. Now, in presentations like this, I don't like to quote judges and I don't like to quote lawyers because we confuse everything. As I said at the beginning, don't let me talk too long. And this is no model of clarity. But I want you to see the language because this is being parsed throughout the state. I think what this says, well, I know what this says. It says we will analyze an operational conflict by considering whether the effectuation of a local interest would materially impede or destroy a state's interest, recognizing that a local ordinance that authorizes what state law forbids or that forbids what state law authorizes will necessarily satisfy the standard. Sorry for reading. I think that says two things. Local governments' regulations are illegal if they conflict in any way with state law, including regulations. What the court did here is even if there's no conflict, the local government law is still illegal if it materially impedes the state's interest. Now, what does materially impede mean? We don't really know, but it is certainly a safety valve for a judge to say, this local government regulation is illegal even though it doesn't conflict if I perceive it to somehow impinge upon the state's primary jurisdiction to regulate oil and gas. The point is, for the first time really ever, we now have a clear test. And this is just as important. This is how that test will be applied. In virtually all cases, the operational conflict test will involve a facial evaluation of the respective statutory and regulatory schemes, not a factual inquiry as to the effects of those schemes on the ground. And what the heck does that say? I think what it says is that all a court has to do in deciding whether a local government regulation is legal or illegal is hold it up, look at it, and compare the language to state law. Now that sounds obvious. That sounds not very surprising. But for those of you who have been involved, God forbid, in civil litigation, you know that civil litigation takes several years to resolve. It oftentimes involves the exchange of tens of thousands, if not hundreds of thousands of documents that are then parsed over by experts. And it involves things called depositions, which is sworn testimony that can take several days. What the Supreme Court is saying here is none of that applies to an operational conflict test. Operational conflict cases should be resolved on summary judgment within a few months of the filing of the complaint, rather than after years of discovery and pleadings. Think about what that means. If you're a landowner and an oil and gas operator gets a permit near you, and you don't think it should have on operational preemption grounds, you can sue both the local government and the operator under operational preemption and probably get a decision in 2-3 months. If you're an operator and you don't like how a local government regulator is treating you with regard to your permit, you can sue and probably get that case resolved in 2 or 3 months. It's remarkable for those of you who've been involved in litigation, and I submit that it is a huge sea change. So in the Longmont case, Longmont tried to string out the Longmont litigation by arguing factual matters. Longmont said there's no material impediment to our ban because nobody's fracking in Longmont anyway. What's the material impediment? Longmont said there's no material impediment to our ban because there are alternative ways of efficiently developing oil and gas that don't involve hydraulic fracturing. And Longmont said we have to protect our citizens because of the safety of fracking. All factual issues, right? Court said we don't need to resolve any of those. We're just going to compare the statute and the regulation. So I think the importance of these decisions can't be overstated. I think for the first time we have a clear test and a clear idea of how that test will be applied. What are local governments actually doing? Are they taking the right way or the wrong way? Let's start with Boulder County. I hear chuckles. As many of you know, Boulder County has a moratorium that's been in place for over 5 years through a series of amendments and extensions. And it's famously been sued by Cynthia Kaufman, the state AG. KOGA and API are both parties to that litigation. And essentially the case argues that the moratorium has gone on for 5 years, so on its face it is violative of the Fort Collins decision. Now, that moratorium is due to terminate on May 1st, in which case the lawsuit will become moot if it is indeed terminated. For any of you who've sat through hearings in Boulder County or Lafayette, you know that the Board of County Commissioners there are under a lot of pressure to extend the moratorium. A lot of people in Boulder don't want hydraulic fracturing in any way, shape, or form. Legal consequences be damned. I've heard as much over many a 12-hour hearing. And for those of you who participated in these hearings, I think you know what I mean. But if the Board of County Commissioners does indeed terminate the moratorium, they have a robust set of regulations. And the question then becomes, are these regulations legal? Now, when I said earlier local governments are sort of mimicking the Colorado Oil and Gas Commission by having hundreds of pages of regulation that regulate virtually every aspect of oil and gas, Boulder is a good example of that. These are regulations that are very expansive, that have to do with air and water regulation, and that have to do with how the regulation will be done, how it'll be monitored, how it'll be tested, where oil and gas wells will be located. All areas that historically have been viewed as within the COGCC's jurisdiction. So the million-dollar question is, are these regulations legal? Before we talk about that, I need to get into the weeds a little bit. Forgive me, but I think you'll see why this is relevant in a couple of minutes. There are two legal ways to challenge local government regulations. One is a facial challenge, and it's what I've been talking about. You just compare the language of the statute and the language of the regulation. The second way is called an as-applied challenge, and that's what happens when an operator actually goes through the permitting process and may have permit conditions. And in operational preemption, you don't just compare the Boulder County regulation, you also compare the Boulder County permit conditions to see if there's an operational conflict. Boulder County, and we'll see that this is being mirrored throughout the Front Range by local governments, has passed some very broad land use-based regulations. An application will be reviewed to see if it is harmonious with surrounding uses, to see whether it degrades natural resources and wetlands, to see if it is detrimental to public health and safety. Those are all land use words, and they're all appropriate in a local government regulation. But the issue here is they govern every aspect of oil and gas, don't they? At the same time, you can't say that they facially conflict with state law. How can something conflict with the words compatible, harmonious, degrade? It's only when an operator goes through the permit process and there are specific air and water standards. Only when an operator goes through the process and there's a specific air and groundwater monitoring testing system. It's only when an operator goes through a process and Boulder County has used its mitigation abilities to perhaps relocate the well. That's when an operational conflict test comes into play on an as-applied basis. And I've gone into this to some extent because we've already seen the first generation of litigation on operational conflict, where we've gotten a standard, we've gotten how it'll apply, and we know that local governments can ban hydraulic fracturing. The next step is going to be much more in the weeds, because it'll be an operator in Boulder, in Adams, in Broomfield or Thornton, or likely in a jurisdiction we're not even mentioning, who's gone through the land use process, had these very broad-based performance standards applied to it, and it is saying, you can't do this. First of all, I can't meet these standards, and you can't impose these standards because they conflict with state law. Just to reiterate, you can't have a facial challenge with words like harmonious and detrimental and degradation. But when you have a permit and an operator knows it has to sample twice as much groundwater, twice as much as it does under the COGCC regulations, or has to meet noise standards that are much more stringent than COGCC regulations, or pay a disruption fee to nearby citizens when the COGCC doesn't even encompass such a fee, that's when you start having operational conflict issues. I predict that in the next 2 years, you'll see an operator bring these issues in front of some local government. It'll go all the way to the Supreme Court, and we will have a roadmap then, more precise roadmap of what local governments can and can't regulate. My prediction is a lot of these regulations will get struck down, but believe me, I have been wrong before, and it is really hard to predict such an emotionally charged and politicized issue as oil and gas regulation in this state. So we need to talk about Lafayette. And this is the last jurisdiction I'm talking about because this is sort of a sideshow to operational preemption. Lafayette last month enacted the Climate Bill of Rights and Protections, which provides residents and ecosystems in Lafayette the right to be free from all activities, including the extraction of coal, oil, or gas, which threaten physical and neurological systems. Well, what is this right? What is the scope of this right, and is it valid? The right, again, if you sit through in Lafayette, public hearings, or even Boulder, and I've heard this in other jurisdictions too, you will hear some very savvy citizens get up and say, we know you, City Council, can't ban oil and gas under Longmont. But there is this natural right, fundamental right, called the right to environmental protection, that circumvents that whole operational preemption nonsense in Longmont and gives us the right to argue that you should ban hydraulic fracturing. In other words, it's viewed as an end run around operational preemption. And believe me, this is occurring in Colorado, but it's really occurring in other states too. This is a national movement. Unfortunately or fortunately, from your perspective, courts have not been very receptive to the idea. I cite the Southgate case up there. It's cited to a lot of venerable Supreme Court cases, none of which have recognized this right. And we all know that fundamental rights in the Constitution are very limited in scope, and it is very difficult to expand that list. There are the rights associated with the Bill of Rights. There's a right associated with marital privacy. There's the fundamental right to educate your child. There's a fundamental right to abortion, at least for now. There is no fundamental right, almost every court has found, to environmental protection. Now, I've coached this by saying virtually every court, because there's one decision by a district court in Oregon that did, in a similar petition to Martinez, which we'll be getting to, say there is a fundamental right to a life-sustaining ecosystem. It characterized that as a very narrow right. That case is now on appeal to the Ninth Circuit. But I highlight this because even though there's not a lot of legal support for it now, as I said at the beginning, this is a really fast-changing area. And in 2 years, when somebody's given this talk, there may be some other cases that actually support this decision. And that's a whole different legal battle than Longmont and Fort Collins. The last topic on operational preemption is moratoria. This is one of the few issues that the Fort Collins court left vague. The court did strike down Fort Collins' 5-year moratorium, but it specifically said, we express no views as to the propriety of a moratorium of material shorter duration. The Supreme Court just held up its hands like this judge and said, we don't have to address it, and we're not going to. This is relevant because we see local governments threatening or actually imposing short-term moratoria all the time. Broomfield a couple of months ago almost imposed a 6-month moratorium. As I mentioned, Boulder has extended short-term moratoria for over 5 years now. And because the Supreme Court didn't resolve this issue, I promise you it's going to keep coming up. And it's going to be something else that we're going to have to talk about in a couple of years when we talk about operational preemption. Now, even though the court didn't resolve the issue, I think it lifts suggestions that even a shorter term moratorium is illegal. I won't bore you with all the details right now. I do want to point out, though, that the one case it's cited, and there's no Colorado precedent, was a New Jersey case called One Claridge House, in which the New Jersey Supreme Court struck down a one-year Atlantic City ban on conversion of rental units. So at least our Supreme Court, while not ruling, cites favorably to a case that strikes down a one-year moratorium. But again, that's just a clue. This is a battle that has to be fought in the future. Now, in the future, because operational preemption is a state creature, this is how it's going to have to be resolved. I don't know where this picture took place, but presumably it could be a number of different jurisdictions. For those of you who can't see it, it's legislatures fighting, which we know occurs. What legislation is on the horizon? Well, we don't know yet, but we have some clues from the past. Last session, House Bill 1355 allowed any local government to designate a mineral resource area and impose regulations upon oil and gas activity within that area, more stringent than COGCC regulation. The sponsor of this bill assured KOGA that it was not meant to trump the COGCC's regulatory authority, but a fair reading of the statute, of the regulation, of the proposed bill, because it allowed local governments to impose more stringent regulations, certainly suggested that it did. Now, this bill died in the House from uniform Republican opposition and 4 or 5 Democrats who joined in. There have been rumblings this term that we would see a local control bill. We haven't, but I guarantee you we will in future sessions and on future ballot measures. Remember, Raise the Bar only deals with constitutional ballot issues. It's only if you're amending the Constitution that you need 55% of the popular vote on a ballot. For statutory changes, it's just the old 51%. So let's keep our eye on local control legislation. And then setback legislation, I'm sure many of you are familiar with the Foot Bill, which died just recently. That changed for at least schools. It said all oil and gas operations have to be not just 1,000 feet from the school boundary, but from the property boundary itself. That died as well, but I'm sure we're going to be seeing setback legislation in the next legislature. And again, we'll see some statutory ballot measures to that effect as well. Finally, the Martinez decision. Just to wrap up our discussion. It's a fascinating case for those of you who haven't read it. It arose from a petition from a bunch of school kids for rulemaking seeking a ruling precluding the COGCC from issuing any drilling permits until the best available science demonstrates that drilling can occur in a manner that does not impair the environment. Now this obviously is a very far-seeking petition that, to put it mildly, would slow down issuance of permits by the COGCC, perhaps stymie them altogether. And it's also a rulemaking that I think could take several years. The COGCC denied the petition because it said it required consideration of environmental impacts alone rather than a balancing of multiple factors. What the COGCC has historically done, or at least what it said it historically did, was to consider all petitions for rulemaking, as well as for all permits, from an historical balancing approach. Environmental is one factor. What's the environmental impacts? But weighed equally with it is its mandate under the Oil and Gas Conservation Act to maximize the efficient production of oil and gas. And so it refused to even consider the petition because it said the petitioners were seeking it to make a rulemaking judgment outside of the authority given to it by the Act. The Act required a balancing. Petitioners wanted only environmental considerations to be considered. The trial court said, nope, you're wrong. It's the petitioners who are right. The trial court said that we've looked carefully at the Oil and Gas Conservation Act, and we think it requires you, the COGCC, sure, you can consider efficient production, but you need to consider environmental impacts on their own merits and not as part of a balancing test. Now, it's a limited decision procedurally, right? The court didn't mandate that a rulemaking occur. It remanded to the COGCC for reconsideration of its decision that it didn't have authority. And God forbid, the court certainly didn't mandate how such a rulemaking should turn out. Didn't say, we agree with the petitioners that we need that third-party study. Of course, the court didn't do that. But I think it still has huge implications if it's not reversed in Colorado and nationally. Because by throwing out the balancing test and yet not providing any guidance as to what level of environmental impairment is permissible, trial court, or the appellate court could be interpreted as saying, you can't have a rulemaking, grant a rulemaking, or grant a permit if it will have any impact on the environment whatsoever, any impact. Trial court didn't say that, but that's an interpretation. And that's one that I'm hearing a lot now from environmental groups and even a few local governments. Will this case be reversed? So the status right now is the COGCC, I may be corrected here in a second, but my understanding is they are going to appeal it, file a petition for cert with the Supreme Court. I think May 4th is the deadline. API, which is also a party, is also going to appeal, and KOGA is going to be filing amicus briefs because KOGA is not a party. Now, the Supreme Court accepts 2 to 3% of the petitions for cert, right? But most of those are criminal cases. And I think in this case, where you have an agency actually appealing and something of this monumental impact, I would be surprised if the court didn't accept cert. Let's say it does accept cert. What will the court rule? Well, again, I've been wrong a lot, and this is a tough area to predict. But there are certainly grounds for the Supreme Court reversing the appellate court. Ignore the multiple goals of the Act. The appellate court only looked at environmental. And I lied earlier when I said there are a couple of different goals under the Act. Production of oil and gas, efficient production of oil and gas, and environmental. In fact, there are 2 more that are mentioned: protection of correlative rights and prevention of waste. So there are at least 4 goals in the Oil and Gas Conservation Act that have to be balanced by the COGCC in making any decision, including whether to grant a petition for rulemaking. The appellate court ignored those. It considered the environmental issues in a vacuum, and I think that makes it susceptible for reversal. If you go through the Oil and Gas Conservation Act and the COGCC regulations, every time environmental impairment and environmental mitigation is measured, or virtually every place, it also mandates technical feasibility and cost effectiveness. And notably in the Oil and Gas Act itself, which both the majority in the trial court, in the appellate court, and the dissent focused on, those words appear as well. And as Judge Boras in dissent said, how the heck can you ignore a balancing test when on its face the regulation balance environmental remediation with technical feasibility and cost effectiveness? That in and of itself is a balancing. I think the Supreme Court might agree. Finally, there's this whole issue of judicial deference I referred to when I started. You know, courts have traditionally deferred to agencies' interpretations of their enabling statute. Courts have historically not had to agree with the agency. Courts have only had to say, it's a reasonable interpretation, or it's ambiguous, but you're not completely wrong, agency, and they've deferred to the agency. I think what the appellate court did here was a form of judicial activism in saying, our interpretation is better than yours, COGCC. And that overturns hundreds of years, at least 100 years, of judicial deference by courts to agencies. And so I think you're going to see the Supreme Court take notice of that as well, if the Supreme Court considers the case. But nevertheless, even if the case is reversed and the COGCC is allowed to go back to its old way of doing things with this balancing test, this is a trend that cannot be ignored nationally or in Colorado of courts second-guessing agencies when environmental impacts are at issue. So you're probably feeling like this right now? After a nice lunch? I think about reaching my limits of lecturing to you. This is the conclusion. We now have a pretty clear guideline of what the operational conflict test and how it should be applied. A number of key issues remain that will represent the next generation of litigation, and it will occur in the next 2 years. How extensive can local government regulations be? Can they regulate technical aspects of oil and gas if they conflict or even if they agree with COGCC regulation? A really interesting question is, can a local government copy state law but give itself the right to enforce it? I think they probably can't, but that's to be decided. We've talked about the fundamental right to environmental health and safety. Are we going to get a decision like the Martinez appellate court that comes from left field in Colorado that enshrines that right? And what are the consequences if it does? Is the court going to rule on whether a 6-month moratorium is legal or illegal? That's an issue that has to be decided that hasn't been. So, in conclusion, this is a highly politicized, fascinating area. It's fascinating to me because it meshes politics and law. But the fracking battle is far from over. In fact, I think in some ways it's just getting started. Thank you very much.
Thank you. So my question is, if Martinez stands with the Supreme Court, doesn't that set up the unintended consequence then of being able to bring that argument related to everything, windmills, new buildings for factories, new retail buildings? Couldn't you bring that argument for everything and essentially shut down all commerce in the state?
You know, perhaps, but it's important to recognize the context in which Martinez is being raised, which is a COGCC rulemaking, and the COGCC just regulates oil and gas. What's really interesting about your question, though, is that Lafayette Bill of Rights we saw. I mean, if people have a fundamental right to be free from environmental impairment, then why wouldn't it apply to a retail shopping mall? Why wouldn't it apply to a dry cleaner? Anything that could possibly impair the environment could be fodder for a lawsuit brought by citizens of Lafayette. So I don't think Martinez quite extends that far, but I think that the fundamental right we spent some time talking about in Lafayette does. And boy, if that is upheld by a court, there's a lot of work for me, but I think a lot of confusion for both local government folks and developers in the room.
Over here.
John Justman from Mesa County. My question is, if it's so dangerous to drill in those counties, why should those areas, excuse me, local governments be able to enjoy all the products that are produced with the oil and gas production from everything imaginable? I don't think they should be allowed to have any, live without it.
Should I even touch that? It's important to recognize, I do want to say that I speak with the utmost respect really for, I know folks in Boulder County, I know folks in Adams County and Arapahoe County. These are really dedicated public officials who are trying to do the best. And they do not believe in a ban on hydraulic fracturing. Notice I didn't mention Lafayette. They do not believe in a ban in their entire jurisdiction. They are talking about extensively regulating oil and gas to allow production, but to minimize its impacts. They misinterpret the authority they have, I think. They think I am equally misguided. But the ones that I have dealt with and I'm talking to aren't coming quite from the focus of perhaps some folks in Lafayette and elsewhere saying we don't want any production whatsoever. I think that's fair.
Yeah, yes, sir. Thanks for being here today. I was wondering, in the case of Boulder, what were the primary reasons why they wanted to ban the fracking, and how did that parallel with the Longmont moratorium?
That's a great question. There are a couple of reasons why they extended the moratorium. Remember, Boulder is not a ban the way Longmont was. It was an extension of short-term moratoria. Now, it was continuous. And so what state and KOGA and API were arguing is, if you have 12 six-month moratoria back to back to back to back to back, how is that really different than a 6-year moratorium? The reasons they gave, and I think these are legitimate, although I don't think banning is, I think they're legitimate reasons, is they were concerned about the public health safety of hydraulic fracturing and thought more studies needed to be done. They were concerned about the traffic impacts, and they didn't think traffic was adequately quantified. And they wanted to come up with new regulations, which they've finally done. It took them quite a while, that really put them, the county commissioners, in the driver's seat, which to me opens up a whole operational preemption can of worms, doesn't it? But so that they could mitigate all aspects of oil and gas because they didn't trust the COGCC to do so for them. Those are the primary mitigating factors, they thought. Does that answer your question?
Yeah, and how did that parallel with Longmont's decision in their case?
So,
Is that the same reason?
it's interesting. The Longmont and Fort Collins cases came down in May of last year, so 11 months ago. Within 2 weeks, Boulder County terminated one moratorium, which had been in place for 3 years, and the same meeting reinstituted a new moratorium. So, and in this litigation, they have argued that those are two different moratoria, and so neither exceeded 5 years in length. So that is how Boulder County sought to address the Fort Collins 5-year limit while keeping their moratorium in place. And this legal issue I don't think is going to be resolved if new regulations come into place May 1st, because the moratorium won't be in effect, and so the litigation essentially goes away. I think it will have served its purpose, because at least we're dealing with regulations now and not an ongoing ban. Yes.
Okay,
Steve?
my name is Steve Odorizio. I'm one of the Adams County Commissioners, and you cited the old Adams County special use permit process language, which is actually the land use language for our normal special use process. Since then, what we implemented last year was the AUSR, the Administrative Use by Special Review, and it was the industry that gave us the criteria, and we removed specifically the criteria that was initially proposed, which included health, safety, and welfare, and we used a compatibility criteria that was given to us by industry and agreed by industry. So I just wanted to set the record straight that there's two different processes, and the old process is the one that you cited as that criteria. And since then, we've had 4 permits successfully go through the AUSR process, and we haven't had any hearings or any sort of even close to denials on this.
That's a fair point, but let me ask you a clarifying question. Are you guys, I just went through the Arapahoe County regs. Are you guys similar to Arapahoe in that there are 2 processes, an administrative process if you sign an MOU, but if you don't sign an MOU, you do go through the USR?
That's correct.
Does the USR criteria, if you don't get an MOU, does it, I think it mirrors this.
No, actually, and that's the distinction between us and Arapahoe, is that you either go, if you don't sign the MOU, you go through the special use permit process, which is the run-of-the-mill land use criteria, which is what you mentioned on the board. If you sign the MOU, you could go through the use by special review process. Now, Arapahoe still has health, safety, and welfare in that one piece of criteria, which is close to this. In our fun time we had last year, we removed that and replaced it with the compatibility with the agreement of industry.
Well, this is really interesting. Why did you remove it, Steve?
Because industry raised such a stink about it, we were trying to avoid the preemption issue, and we were trying to focus more on the land use piece, which actually brings me to a real question. Is we always say that there's still land use authority. Locals can still do land use. And I've never gotten a really good grasp or any answer what land use things and powers actually still exist now for local governments.
Yeah, you know, I spent a couple of days with Jake Matter before the Longmont argument and the Fort Collins argument in December of 2014 on that exact question. Because if you read the operational conflict language literally, and this is language, of course, before the Longmont case, but it was somewhat similar about conflict, there's not much for local governments to regulate, is there? Because the COGCC regulations are so extensive. Traffic, for sure. Road impact, for sure. Clearly, local governments can have a permitting process and a building permit process for aspects of visual mitigation above the ground. I think local governments can probably regulate noise, but that's questionable. There are a list of 7 or 8 items that we came up with because we anticipated this question from the Supreme Court, and thankfully they weren't as smart as Steve and didn't ask it. And it's hard, because if you take the Longmont operational conflict language series seriously, there's only 7 or 8 issues, none of which are that extensive, apart from traffics and roads and above ground mitigation for local governments to regulate. That's why this next generation of cases is going to be so important. Because I think the argument I just made flows directly out of the Longmont decision. But imagine if that is actually upheld, it would gut 3/4 of what local governments now think they can do with regard to oil and gas regulation. It would gut 3/4 of the regulations they have just enacted. Most aren't as perspicacious as Adams County and removing performance-based standards. That language may not be applicable anymore to Adams, and I apologize if it's not, but it's certainly applicable to about 10 other jurisdictions in the Denver Front Range. That's a far cry from what we are talking about if Longmont is taken seriously in the next Supreme Court decision. So great question, and I don't have a great answer for it, despite spending 2 days preparing for it. Hey, Matt, go ahead.
Mark, Matt Lepore from COGCC again. Just need to make sure everybody's on the same page. No final or formal decision has been made by the agency with respect to whether to appeal the Martinez decision. Your reasoning is persuasive, however.
I think it's fair to say even if the COGCC doesn't appeal it, API will. So there will be a petition for cert filed. I mean, the impact of the case is just too significant, I think, for the industry or the agency to walk away from for the reasons we've discussed. All right. More questions? Thank you very much.